2017 Remedial Law Bar Question Part 2, number 11 to 19. 2017 Remedial Law Bar Question number 11A. Teddy filed against Buboy an action for rescission of a contract for the sale of a commercial lot. After having been told by the wife of Buboy that her husband was out of town and would not be back until after a couple of days, the sheriff requested the wife to just receive the summons on behalf of her husband. The wife acceded to the request, received the summons and a copy of the complaint, and signed for the same. Question letter A. Was there a valid service of summons upon Buboy? Explain your answer briefly. Answer to 11AA. No, there was no valid service of summons upon Buboy. The Supreme Court has held that in order that there will be a valid substituted service of summons, the sheriff must have exerted diligent efforts to effect personal service of summons within a reasonable time. Here, there was no such diligent efforts on the part of the sheriff since he effected substituted service on his very first try. Hence, there was no valid service of summons upon Buboy. Bar question 11AB. If Buboy files a motion to dismiss the complaint based on the twin grounds of lack of jurisdiction over his person and prescription of the cause of action, may he be deemed to have voluntarily submitted himself to the jurisdiction of the court? Explain your answer briefly. Answer to 11AB. No, Buboy may not be deemed to have voluntarily submitted himself to the jurisdiction of the court, because under the rules of civil procedure, the inclusion in a motion to dismiss of other grounds aside from lack of personal jurisdiction shall not be deemed a voluntary appearance. Bar question 11B. What is the mode of appeal applicable to the following cases, and what issues may be raised before the reviewing court or tribunal? Letter A. The decision or final order of the National Labor Relations Commission. Suggested answer to 11BA. There is no mode of appeal from a decision or final order of the NLRC, since such decision or final order is final and executory pursuant to the Labor Code. The remedy of the aggrieved party is to file a special civil action for certiorari with the Court of Appeals. Such special civil action may raise question both of fact and law. Question 11BB. What is the mode of appeal applicable to the judgment or final order of the RTC in the exercise of its appellate jurisdiction? And what issues may be raised before the reviewing court or tribunal? Suggested answer to 11BB. The mode of appeal applicable to judgments or final orders of the RTC in the exercise of its appellate jurisdiction is a petition for review under Rule 42. The petition may raise questions both of fact and law. Bar question 12A. Judgment was rendered against defendant JP in an action for unlawful detainer. The judgment ordered JP to vacate and to pay attorney's fees in favor of Bart, the plaintiff. To prevent the immediate execution of the judgment, would you advise the posting of a supersedeas bond as a counsel for JP? Explain your answer briefly. Suggested answer to bar question 12A. No, as a counsel for JP, I would not advise the posting of a supersedeas bond because under the Rule 70, a supersedeas bond is necessary to prevent immediate execution only if the judgment awarded rents, damages, and costs. Here, the judgment only awarded JP to vacate and to pay attorney's fees. A supersedeas bond is not required to cover attorney's fees. Hence, the posting of a supersedeas bond is not required. Bar question 12B. A temporary restraining order was issued on September 20, 2017 by the RTC against defendant Jeff, enjoining him from entering the land of Regan, the plaintiff. On October 9, 2017, upon application of Regan, the trial court, allegedly in the interest of justice, extended the TRO for another 20 days based on the same ground for which the TRO was issued. On October 15, 2017, Jeff entered the land subject of the TRO. May Jeff be liable for contempt of court? Why? Suggested answer to bar question 12B. No, Jeff may not be liable for contempt because under the rule on preliminary injunction, a TRO is effective only for a period of 20 days from service on the person sought to be enjoined. It is deemed automatically vacated if the application for preliminary injunction is denied or not resolved within the said period, and no court shall have the authority to extend or renew the TRO on the same ground for which it was issued. Here, the extension of the TRO by the RTC was invalid since it was for the same ground for which the TRO was issued. Hence, the TRO was deemed automatically vacated and thus Jeff may not be liable for contempt for ignoring it. Bar question number 13. Police officers arrested Mr. Draghi in a buy-bust operation and confiscated from him 10 sachets of shabu and several marked genuine peso bills worth 5,000 pesos, used as the buy-bust money during the buy-bust operation. At the trial of Mr. Draghi for violation of RA number 9165, Comprehensive Dangerous Drug Act of 2002, the prosecution offered in evidence, among others, photocopies of the confiscated marked genuine peso bills. The photocopies were offered to prove that Mr. Draghi had engaged at the time of his arrest in the illegal selling of dangerous drugs. Invoking the best evidence rule, Attorney Maya Bang, the defense counsel, objected to the admissibility of the photocopies of the confiscated marked genuine peso bills. Should the trial court or should the trial judge sustain the objection of the defense counsel? Briefly explain your answer. Suggested answer to bar question number 13. No, the trial judge should not sustain the objection that invokes the best evidence rule, because the Supreme Court has held that the best evidence rule applies only to documentary evidence and not to object or testimonial evidence. Here, the marked money is object, not documentary evidence, since it is being offered to prove not its contents, but its existence and use in the buy-bust operation. Question number 14. Immediately before he died of gunshot wounds to his chest, Venancio told the attending physician in a very feeble voice that it was Arnulfo, his co-worker, who had shot him. Venancio added that it was also Arnulfo who had shot Vicente, the man whose cadaver was lying on the bed beside him. In the prosecution of Arnulfo for the criminal killing of Venancio and Vicente, are all the statements of Venancio admissible as dying declarations? Explain your answer. Suggested answer to bar question number 14. No, not all the statements of Venancio are admissible as dying declaration, because under the rules on evidence, a dying declaration is admissible as an exception to the hearsay rule provided that such declaration relates to the cause of the declarant's death. Here, Venancio's statement that it was Arnulfo who shot him is admissible as a dying declaration. The same related to Venancio's own demise. It may be inferred that Venancio had consciousness of his impending death since he suffered gunshot wounds to his chest, which would necessarily be mortal wounds. However, Venancio's statement that it was Arnulfo who shot Vicente is not admissible as dying declaration, since it did not relate to the cause of the declarant's death but to the death of another person. Question number 15. In attempt to discredit and impeach a prosecution witness in a homicide case, the defense counsel called to the stand a person who had been the boyhood friend and next-door neighbor of the prosecution witness for 30 years. One question that the defense counsel asked of the impeaching witness was, can you tell this honorable court about the general reputation of the prosecution witness in your community for aggressiveness and violent tendencies? Would you, as the trial prosecutor, interpose your objection to the question of the defense counsel? Explain your answer. Suggested answer to bar question number 15. Yes, as the trial prosecutor, I would interpose my objection to defense counsel's question on the ground of improper impeachment. Because under the law on evidence, an adverse party's witness may be properly impeached by reputation evidence, provided that it is to the effect that the witness's general reputation for honesty, truth, or integrity was bad. The reputation must only be on character for truthfulness or untruthfulness. Here, the evidence is not on the prosecution witness's general reputation for honesty, truth, or integrity, but on his aggressive and violent tendencies. The evidence had nothing to do with the witness's character for truthfulness or untruthfulness. Hence, the impeachment was improper. Bar question number 16. Engineer Magna Nakaw, the district engineer of the DPWH in the province of Walang Progreso, and Mr. Porkchop, a private contractor, were both charged in the Office of Ombudsman for violation of Anti-Graft and Corruption Practices Act, RA number 3019, under a conspiracy theory. While the charges were undergoing investigation in the Office of the Ombudsman, Engineer Magnanakaw passed away. Mr. Porkchop immediately filed a motion to terminate the investigation and to dismiss the charges against him, arguing that because he was charged in conspiracy with the deceased, there was no longer a conspiracy to speak of, and consequently, any legal ground to hold him for trial had been extinguished. Rule on the motion to terminate the investigation filed by Mr. Porkchop with brief reasons. Suggested answer to bar question number 16. Mr. Porkchop's motion to terminate the investigation before the Office of the Ombudsman is denied. In a case involving similar facts, the Supreme Court held that the death of a co-conspirator, even if he was the lone public officer, did not mean that the allegation of conspiracy to violate the anti-graft law could no longer be proved, or that the alleged conspiracy was already expunged. The only thing extinguished by the death of a co-conspirator was his criminal liability. His death did not extinguish the crime, nor did it remove the basis of the charge of conspiracy between him and the private respondent. Bar question number 17. Wancho entered a plea of guilty when he was arraigned under an information for homicide. To determine the penalty to be imposed, the trial court allowed Wancho to present evidence proving any mitigating circumstance in his favor. Wancho was able to establish a complete self-defense. Convinced by the evidence adduced by Wancho, the trial court rendered a verdict of acquittal. May the prosecution assail the acquittal without infringing the constitutional guarantee against double jeopardy in favor of Wancho? Explain your answer. Suggested answer to bar question number 17. Yes, the prosecution may assail the acquittal without infringing upon the constitutional guarantee against double jeopardy. Because under the rules of criminal procedure, a requirement for a first jeopardy to attach is that there must have been a valid plea by the accused. Said rules also provide that when the accused pleads guilty but present exculpatory evidence, his plea shall be deemed withdrawn, and a plea of guilty shall be entered for him. Here, Wancho's plea of guilty was deemed withdrawn when he presented exculpatory evidence to the effect that he acted in self-defense. Hence, his plea of guilty was deemed withdrawn, and a plea of guilty should have been entered for him by the court, which, however, was not done. Since there was no standing plea, a first jeopardy did not attach, and thus prosecution may assail the acquittal without infringing upon one's right against double jeopardy. Bar question number 18. Thomas was criminally charged with the serious physical injuries allegedly committed against Darwin. During the pendency of the criminal case, Darwin filed a separate civil action for damages based on the injuries he had sustained. Thomas filed a motion to dismiss the separate civil action on the ground of litispendentia, pointing out that when the criminal action was filed against him, the civil action to recover the civil liability from the offense charge was also deemed instituted. He insisted that the basis of the separate civil action was the very same act that gave rise to the criminal action. Rule on Thomas' motion to dismiss with brief reasons. Suggested answer to bar question number 18. Thomas' motion to dismiss on the ground of litispendentia should be denied. In cases of physical injuries, a civil action for damages, entirely separate and distinct from the criminal action, may be brought by the injured party. Such civil action shall proceed independently of the criminal action, and hence may not be dismissed on the ground of litispendentia. Bar question number 19. Boy Maton, a neighborhood tough guy, was arrested by a police officer on a suspicion that he was keeping a prohibited drugs in his clutch bag. When Boy Baton was searched, immediately after the arrest, the officer found and recovered 10 sachets of shabu neatly tucked in the inner linings of the clutch bag. At the time of his arrest, Boy Maton was watching a basketball game being played in the town plaza, and he was cheering for his favorite team. He was subsequently charged with illegal possession of dangerous drugs, and he entered a plea of not guilty when he was arraigned. During the trial, Boy Baton moved for the dismissal of the information on the ground that the facts revealed that he had been illegally arrested. He further moved for the suppression of the evidence confiscated from him as being consequence of the illegal arrest, hence the fruit of the poisonous tree. The trial court, in denying the motion of Boy Maton, explained that at the time the motion were filed, Boy Maton had already waived the right to raise the issue of the legality of the arrest. The trial court observed that pursuant to the rules of court, Boy Maton, as the accused, should have assailed the validity of arrest before entering his plea to the information. Hence, the trial court opined that any adverse consequences of the alleged illegal arrest had also been equally waived. Comment on the ruling of the trial court. Suggested answer to bar question number 19. The ruling of the court denying the motion for dismissal of the information on the ground of illegal arrest is proper, because under the rules of criminal procedure, the accused's failure to file a motion to quash before plea is a waiver of objection to lack of personal jurisdiction or of the objection to an illegal arrest. Here, Boy Maton entered the plea without filing a motion to quash on the ground of lack of personal jurisdiction. Hence, he is deemed to have waived the ground of illegal arrest, which is subsumed under lack of personal jurisdiction. However, the ruling denying the motion to suppress evidence is not correct, because the Supreme Court has held that a waiver of an illegal warrantless arrest does not carry with it a waiver of inadmissibility of evidence seized during an illegal warrantless arrest. A waiver of an illegal arrest is not a waiver of an illegal search. The Constitution provides that evidence seized in violation of the right against illegal search is inadmissible in evidence. Hence, the evidence seized was by virtue of an illegal search. Since the arrest was illegal, hence such evidence may be suppressed. Believe and trust the Lord, and trust yourself that you can do it and you will pass the bar. Thank you for watching, and please like, subscribe, and share my video. Thank you and goodbye.